Well, Sarah Boone is off to the races in court, and it's going to be a slow, painful race. And is she going to be taking a plea deal? Let's talk about it in today's video. I want to thank today's sponsor, TesterUp, for making this video possible. Y'all, I've been earning money from the sofa, from the bed, from the other sofa, and all around with TesterUp. So what is TesterUp? Well, I'm going to tell you. TesterUp is an awesome platform. It lets you try out games, take surveys, complete tasks, all sorts of things, and you can earn real money, real PayPal money. And registration and testing apps is free. So once you become a member, you get access. You test out this huge selections. And like I said, it's surveys, games, products, cosmetics, you name it, right? Now, after you complete several offers, you become a premium tester and you can unlock even higher paid offers and the possibility to earn more money for your pockets. Okay. One thing I loved about this is it's a huge variety of options in the app. So it's not like pigeonholing you into one kind of game or one kind of survey or one thing like that. There's something there for everyone. And the other good part too is there's a super low payout threshold. It's like $70 within just 24 hours to PayPal. Now for me, this is major. The app's interface is super easy, super intuitive. There's more than 50 tasks available after you register, and there's like 2.7 million members. So trust me, you're in good company. Okay. It's also super flexible where you can do these from. You can use your computer, a tablet, your smartphone, whatever you want to do, right? It's there for you. They get excellent reviews on Trustpilot too, which says a lot. Now for me, as soon as I saw that Monopoly was one of these things, y'all, I dove head first into it, and I have been having so much fun playing this. Half of it's nostalgia, okay? We used to play this family game like around the table, you name it, like it's just kind of been part of my life as a childhood or whatever. So seeing it in this platform was super cool, and the whole time I'm playing it, I'm just like, this is super easy to use and I'm getting paid to do it. Yeah, sold. Sign me up, thank you, please. So look, go ahead, give it a try. You can use the QR code that's going to come up on the screen, or just click the link down in the description below. Go there, test it out, start lining those pockets, start getting that PayPal going, and let me know what you think about it. Hello, Sofa Squad, and welcome back to the sofa. Sofa's back there. My name is Paul, and today, guess what? We are revisiting Sarah Boone. Boom, boom, boom. Or boom, boom, boom. Now, y'all, listen, first things first, couple of things. It is pouring down rain. You can probably hear in the background. It might be ASMR for some of y'all. Probably going to put me to sleep at a certain point, but Sarah will probably wake me right back up, right? So just know that that's going on. Secondly, some of the clips where she talks, this is going to be just a very frustrating thing with this. They don't have a microphone on her in the courtroom, so you might need to turn your volume up. We'll try and fix it in editing and all that kind of stuff, but just know this might be an earbud kind of a situation. Third thing, we did a live chat on the live chat channel. I will put the link below where we watch this verbatim start to finish. It's like right under 2 hours hearing. If you want to watch that vibe of it where we watch the whole thing, then there's that. But for this video particularly, I've picked out certain clips and I'm just going to react to them. And whether you watch the live chat or not, I mean, this is just off the cuff again. So there ain't no telling what's going to come out of my mouth is what I'm getting at. So that being said, that is the vibe for this. And if you are new here, the way we do these is I put clips up and I just basically make commentary on them and react to them. I'm not a lawyer, I'm not a doctor, I'm not a cop, I'm not any of that fancy credentialed stuff. Only credentials are the damn sofa and some sass. Okay, so that's how we roll up in here. Now, if you are unfamiliar with this is the Sarah Boone, aka Suitcase Sarah case. Sarah Boone has been alleged, or she allegedly took the life of her boyfriend George by getting him into a suitcase, and he succumbed to asphyxiation basically. So this has gone viral. This has been going on for 4 or 5 years. She's been in jail. Her antics, she's gone through like 8 lawyers. She has forfeited her right to an attorney through her behavior, and she has gone pro se. She is having to represent herself. She ain't happy about it. And this hearing that we're watching is kind of like her first real, okay, you're representing yourself, here we go, we're addressing 5 motions that you put up, and she has more motions. We do learn some very interesting things throughout. So that's the 60-second version. I have a whole playlist on it. We'll be continuing to cover this. I know a lot of people want me to go to the trial, and I might try and do it. I'll have to see, but I'm not sure if I'll be able to make it or not. But regardless, we'll be covering it probably mostly in the actual trial on the live chat channel, just because we can stream over there. But I'll be doing like highlights and that type stuff on both channels and whatnot until we see some justice in this case, which I think will be swift and quick. Unless she takes a plea deal, which we will hear some about in this, so we'll talk about that. So let's go ahead and get that first clip up and let's get to going.
The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense in trial dated July 18, 24, and received July 29, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined, and the amount of transcripts are unknown.
Okay, so I put that up there because that is the gist of why we're here, right? So you heard all the things. He's going to be going over all these motions. Now, way more information will come out throughout, but I just want to start that clip off for those who didn't watch or are unfamiliar to give you the gist of this is what's going on here. She, remember, has handwritten these motions. They are available on the Orange County Clerk of Courts website, and then I do videos on them too or whatever, but if you just want to go look them up for yourself, and that, of course, is out in Florida. So that's the gist. Let's keep going.
All right, ma'am, so previously Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose.
Okay, so again, just very quickly, you heard the outcome of some of these. Now, here's my take on this judge. To me, the judge is incredibly fair, right? He has bent over backwards, as well as the state, the JAC, the investigator. All these people are bending over backwards for her, but it's never enough, right? Now, of course, they're trying to really dot their I's and cross their T's at this point to avoid, appeals and this kind of stuff, which 100% she'll do. Now, what he said there towards the end where he denied those with prejudice, and remember, I'm not a lawyer, this is just my opinion from watching these cases and following them, is I get it, because and I get both sides of that, even though I have a bias, obviously, against her, it is what it is. She has put herself in the situation where she has to represent herself. She is not qualified to at all. And so she doesn't know how this works. Like, okay, well, I don't know how much the money I need. I don't know who the people are. And so he's like, well, look, I can't sit here and just, here's a check, but here's a blank check for you, Sarah. Have fun. You know what I'm saying? Like, this is the problem she's going to run into representing herself. Me and my ADD, the idea of having to even figure out that one component gives me complete anxiety. I'm like, that could take years. She has weeks, okay? But again, she put herself in this situation. She is in the briar patch, if you remember that children's story. She has gotten thrown in the briar patch, now she's complaining about it, okay? So let's keep going.
Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for, who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date, once I have that information, to revise them?
I'm giving you the opportunity to refile them. Yes, ma'am.
Thank you.
Okay, so this is what I'm talking about. First of all, let's just go ahead and say it. This case right here, this trial, whatever you want to call it, if I ever hear the word discovery again after this, y'all, I cannot. What was the word from Daryl Brooks that we just couldn't deal with? We got caveat from Nancy Brophy. Okay, which it's shocking to me how often I find myself using that word now and never did before. Okay, I never had a reason. Maybe I'm calling myself out. It's like, well, yeah, that's because you're low intellect. Oh, you don't use fancy words. Everybody's like, oh, honey, we know you didn't ever use a big word like that. You didn't have to tell us that. I'm putting myself out on Front Street. I'm not in situations where I need to use fancy words like caveat. Okay, caviar, whatever the hell she's talking about. I'm interchanging them. I'm using caviar. I'd like to add something to that sentence, but with a caviar. Like, what are you talking about? I mean, come on. But anyways, y'all, Discovery, I cannot with that word anymore. I've deleted Discovery Channel off the damn TV, okay? But in all seriousness, so just what she said, this is exactly how this is playing out, right? Okay, well, I was trying to do this, but I didn't know to meet the deadline, and blah, 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 so I can refile. This is the drama she's put herself in. You know, she's like, I don't want to be pro se. I don't want to be pro se. Well, girl, you got to work with people. But she's going to tell on her, the way I'm telling myself with my language, she's going to tell on herself here in a little bit, and we'll get to it.
With regard to the defendant's motion for reservation of proposed cost to With regard to defendant's motion for reservation of proposed cost to acquire expert witnesses for the defendant's defense in trial dated July 18th, 2024 and received July 29th, 2024.
Okay, now real quick, I just wanted to put this in here. So the expert witnessing, dying to see the list. I think in the live chat we were talking about she's gonna have somebody from Samsonite. She's gonna have some crazy expert. I would, again, I'll say it 100 times. If I was her and they were like, okay, Sarah, I'm making these numbers up. Sarah, look, we're gonna give you $3,222.53 for an expert. I'd be like, every last penny is going to a damn shrink to talk about. She doesn't need lock her up in a mental place instead, or whatever she's trying to go for, right? 100%. That's where that whole investment would go, and to the best mental health expert, whatever, that was going to say what I wanted him to say, right? I mean, who wouldn't? Okay,
Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it.
So again, he's just kind of going through all these same motions, right? And again, I get both sides of it. She doesn't need, it's almost like she has to do a placeholder to be like, I know I need to do something with this. Here it is. I don't know. In order to get him to say, okay, well, look, here's what you have to do. I mean, it's just such a slow process, right? And again, it's just made even worse by the fact that she's having to do it herself now. And I'm not saying that that's the judge's fault. I completely consider it Sarah's fault, but you made your bed, you got to lie in it.
Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of a criminal case for trial dated July 18, 2024 and received July 29, 2024. The request, ma'am, that you are seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial.
Okay, now this one, y'all, she's ballsy for putting that one up there. You got to give that to her, okay? She's trying any angle she can get. Now, I just wanted to, again, put these up here so we can hear in full what the motions are that she, that she did and his response to them. Now, this part right here, she's going to revisit this all the way up to sentencing, I can tell you that. This whole thing of her wanting this, and I'm not going to even try to explain it. We're going to let them explain it. Obviously, he's going to deny it for obvious reasons, but when we hear the reasonings behind it, this again is another reason why she should have let somebody who is qualified do their job, right? And point her in the right direction, because you don't understand the basic definitions of law. I certainly want to, you know what I mean? Like, that's the whole thing. It's like, she doesn't have a law degree, so she's not going to know a lot of this stuff, and it's just going to be. Now, does that mean that even if she did know it, she would 100% still be doing this, right? 100%. But it's just, you see the difficulties in it. Let's keep going.
The point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place.
Okay, so exactly. This is what this is. This is for somebody who chose to think Daryl Brooks, right? She's been forced to do this, and like, no, you don't get that. You've exhausted that, because imagine if they gave her one. She would wear that person out, because she would be talking about wanting them to do, she wants them to be her secretary. So she would be like, well, you need to do this and you need to do that. And they've revisited this, and the judge will say that 100 times throughout this whole thing. I'm not revisiting that. I'm not revisiting that. I'm not going to go back in my decision. It's in the 16 pages. He has to spell it out and hold her damn hand.
As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepard v. State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
I feel like after that one, he should have done the invisible hair behind the ear thing. It's denied, girl. Or at least the gavel. Or at least we can make it a little bit more, butch it up for him. The gavel, okay? Maybe the invisible hair thing isn't his vibe, right? But it needed something. Okay, it needed something. Again, I love this judge. He's very fair. He's revisited this. He spells it out for her 100 times over. We've already gone over this, and it's just, I'll say this 100 times throughout this case. And again, I'll say this 100 times too. The first 100 times thing I'm saying is, number one, I'm not a lawyer or any of that. These are just my opinions from watching it from the sofa. Number two, this is what happened. Like, she revisits stuff over and over and over and over, and I understand that in her world she's fighting for her life. She wants to do this, she wants to get it flipped over, she wants the best outcome. Any of us would want that, right? I get that, so I can't fault her for that. But it's like, put your eggs in the basket where it's better suited. She will not give up the thing about getting back a lawyer, and it's like, girl, I know this takes you a long time to research this stuff. You need to be picking other parts of the case apart, and maybe we will see that now that she's getting her discovery, right? Maybe we'll see this now of her energy being put forth elsewhere. I don't know.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision, so I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer, so I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period.
100% he needed the invisible hair thing with that one. And the gavel and a drop mic. Okay, first of all, this is one of the things where she tells on herself, right? In my opinion. The part where she says, I wanted to explain, with the evidentiary hearing, I could have better explained myself. This is the nucleus of what's going on here, in my opinion. She feels like she can explain her way out of this stuff. She probably is like, I want to speak in layman terms. I get that. I would too. She wants that evidentiary hearing or whatever. She'll say this numerous times about explaining herself, and then you would understand. It's the same way that when she did that interview. We might need to revisit the interview again. Not right now, obviously, but I just, intrusive thought. The interrogation that they did with her where they arrest her, we've watched it. I did a video on it, we did a live chat on it, but we might need to revisit it at some point now that we know all this stuff. Actually, somebody emailed me that, asking me about that. That was a good idea. If you're in the comment section, claim your fame on that one. I remember that now. We might do that. Anyways, let me know in the comment section if you want to revisit the interrogation video. Now that we know all the stuff that we know or whatever. Anyways, for this channel. Okay, sorry. Intrusive thought. Squirrel! The nucleus of what she wants to do is explaining things away. She thinks she can explain her way out of this. She thinks she can explain that video of George. She thinks she can talk her way out of this, that, and the other. She will say this numerous times throughout this. If I could explain myself, you know, that is the nucleus of it. And then again, you did hear her say, thank you for explaining to me what the thing was. But you also heard her accusations like, oh, I didn't want to do this. It was unlawful. I was forced. All these things right here. Again, these are key words that she's going to keep bringing up because it only behooves her to do so, right? Again, regardless of how I might feel about her, anybody would want the best outcome for themselves in the situation. You know what I'm saying? So it's like, I get that part of it. I can understand that. But again, it's just annoying as an onlooker to watch and hear when you see the evidence that we've seen and the behavior that we've seen for her to get up there and like try and pivot herself in the light of I'm victim.
The information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
So, I mean, here you go again. She's throwing out these big words, these big accusations, and he just comes right back with, look, you know, basically, I already dotted my I's and crossed my T's. It's in 16 pages. It's a wrap, girl. It's done. You can sit here and tell me that I'm unlawful, I'm this, I'm that, and I'm big meanie judge or whatever you want to call me. It ain't changing the findings. Okay.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
Okay, so we've got the attorneys are lying. You made incorrections in your thing based on their lying. You didn't listen to me explain. Okay, this is what I'm talking about. Listen to what she says throughout. She constantly goes back to explain. If I could only explain. You didn't listen to me explain so I could understand. Girl, we've read your letters. This is how this works. I 100% get what she's talking. It would be much easier to sit down over coffee or a brewski with the judge and be like, look, this is what really happened. I mean, of course it would, right? This is the way this is done. No formal law education at all on her part. But the way the accusations she throws out, same thing that Daryl Brooks did, it's that you can't tell them different, right? They know the law, they read a Google article. They know how to use Wiki and they know the law. But again, just pay attention to how much she goes back to wanting to explain. That's what I think frustrated her so much in the interrogation, where that was her chance to kind of explain and they weren't getting it. They didn't understand that because she didn't mean to, she should be going home with her little list of demands. There's a major disconnect in reality. Major disconnect in reality there. It's frustrating to watch, and how much we talk about the 16-page findings in this case. Oh my goodness, let's keep going.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
You and like we talked about last time, ma'am, you're certainly entitled to that opinion.
So again, I'm not revisiting it. You're entitled to that opinion. He's very fair. And he's just good. This is part of the process where she's representing herself. He's going to have to hold her hand. You would not normally have to do this with an attorney and whatnot, because they're kind of, number one, they're not revisiting the same thing over and over and over. But this is what happens when the judge has to deal with somebody directly, right? And it is kind of interesting to see, because again, anyone thrust into this situation, you're kind of figuring out like, what do I do? How do I do this? And it just makes everything so much more time consuming and difficult, which we will see towards the end in his decision to lengthen the trial.
As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st.
He's like, I've seen enough of this damn mess. He was like, first of all, we're extending the damn trial. Secondly, I'm going to need a damn espresso machine brought in here, a little cot with my favorite blankie, a little pillow. Might need my damn CPAP machine. It's quiet. It's not going to mess with y'all. Okay. That's what I'd be doing. I'd be like, I need a little oscillating fan over here. Okay. I think he's going to end up doing it in 4 or 5 weeks before it's all over with. I'm not going to lie, y'all. I'm not going to lie. Here's the thing. Like, I've talked about going down to try and cover the trial, y'all. Y'all. The items I just named off, legit, like if they panned the courtroom, okay, and y'all are watching, be like, is that Paul? Is that reporting live? I'd be there with my blankie over here, like this damn CPAP machine on, this right here, sleeping. 10 minutes into the damn day. My body would reject, I already know. Once the novelty was over, which would probably be 10 to 15 minutes, I would literally be like, does anybody like maybe want to play like a word game or 2 syllables starts with? You know what I'm saying? I don't know if I can make it through. Like once they start drowning on like this, I'm like, oh my God, I can't take it.
Evidence to be brought here into court by a CSI so that she can potentially open it. Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
Then we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a 2-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court. played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by this.
One thing that I like about a trial or a case like this is, so what we just heard him do and break down, and the way he like broke down, or the other dude, JC, broke down like, okay, this is what a standby attorney is or whatever. They're explaining it to somebody like me, like Sarah, whatever, like in layman terms, right? They're breaking it down and being like, okay, now look, this is what this means. Okay, no ma'am, so this is how the evidence is gonna work. So for me, like, I appreciate that, right? Because it's not like, as I like to say, like fancy talk or whatever, like they're breaking it down to my level. I'm like, okay, cool, got it, okay? Brace yourselves, because this is the theme of so much of this from here on out, is the evidence. And I was like screaming at the TV over this. Okay, I was like, oh my God. Now again, that's me being petty. 100% I get this is, everyone's doing their job, right? She's gonna want access to this. I get it, right? Just as that level, it's like, oh my gosh, this is like, why do we keep going back over this and over this and over this? But again, this is what happens when you represent yourself. You know, and again, I'm not saying it's their fault. You know, I want to be clear on that. Let's keep going.
So it's not a matter of any type of confidentiality. It is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Okay, from a petty sofa level over here, I would kill to be in the room when to see the look on her face when she revisits some of the evidence. From a different side of the fence, 100% I get it, right? It would be odd to have the cameras in there. They probably don't need to have the cameras in there. I get that part. And I understand her wanting to, again, protect herself from the media. I get this, right? Anybody would, but oh my God, I want to see her face when she looks at that video again of the suitcase thing. If she would even look at it. I just know she's going to have something to say. Some facial thing, something. Or she's going to try and like be crying. Like something like that, right? Like she's going to something. Okay, something. Let's keep going.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it, the conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use, these are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use, and then we can have the defendant sign off on that as well.
Okay, key ingredient here, the plea agreement talk. We'll hear this again. Now, what he's talking about is a thing where she's asked to meet with them outside of the jail or court or something like that. So basically, she's requested to talk to the state. And also going over this, you know, how do we do the evidence, the physical evidence, this and that, and blah, 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 blah. And it's this whole cumbersome thing of like, how do we recreate the environment that usually takes place with watching or looking over the evidence, and also the court being able to document this or that or whatever, right? It's a whole thing. And they spend a lot of time on this, but again, key ingredient, plea talks. What I took from this is that Sarah has approached them about a plea deal. That's what I have seen from this. It also makes me wonder if this could have been one of the things that she's run into with her attorneys. Is she saying, and I don't know this, y'all, this is me literally just making these numbers up and everything, sofa speculation 100%. Did she basically be like this? Go tell them I'll do 5 years. And the attorney's been like, they're not going to take that. no, they're not they're going to want to go to trial, or, you know what I'm saying? Like, one of the things like that, they were just like, that's not possible. Like, they're going to want to come at you for more than that. It could be. I'm sure she's been that way on every topic, right? So let's keep going.
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms.
Again, the reason I put this clip in there is from past attorneys, she wants to have a conversation. She, 100%, in my opinion, 100% is wanting to talk plea deals. Okay, I think that's one of her tactics that she's wanted to use, is a plea deal and riding this out for as long as she could to do as much time as she could in county jail and wear them down to get a good plea deal.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain whom I spoke to the other day regarding my laptop, but I would very much...
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni?
Okay.
Now, you hear her, my phone calls have been released, this, that, and the other. And again, I'm sure to other countries that their judicial system is different. It's weird to them. I would imagine, drop it in the comment section if you come from a different country besides America and you have a different, your judicial system is different than this, where we get phone calls released. We have this access to the courtroom, all this kind of information. It is a little bit bizarre, but for the nosy part of me, I absolutely love it, right? I think Sarah has a love-hate relationship with the media. I think she loves the attention. I think it's the most attention she's ever gotten. But it also is like it's a double-edged sword for her, right? Because it doesn't make her look good at all.
Your understanding is different than my understanding, because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get them involved with fear of harassment or anything from other...
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing.
Now, one of the things with this part is, and I've cut this way down just to some key points of her talking and whatnot, because this goes on for a while during the actual proceeding of where I'm taking this from. But she goes back and forth with this whole thing about the court. I don't feel good with the court doing this. And he's explaining what his understanding is of how their, basically what I call like their security protocol for doing like the, the discovery and things of this nature and whatnot. And she doesn't trust it. It's this and that. And he just reverts back to what he's been told. This will be a key ingredient as we see things unfold, because he's going to go by what the jail says, right? And he's going to have to make sure the court's totally cool with you doing A, B, and C. We don't care if you do jump drive. We don't care if you do hard copy. It's the jail, right? And so again, she is all about a circular conversation and revisiting, and you'll see, and you will get to it, why she does this, because people like this eventually get rewarded. They eventually get rewarded with what they want, and that's why they flip out along the way when they can't get it, because they're never used to being told no, and they've been trained by different things, whether it's, well, if I just go to and cause a scene at the grocery store, they'll honor the coupon. Well, if I just do this in court, they'll do that. And they always somehow get rewarded for it, right? They have a way of wearing things down to be like, okay, well, of course their behavior is going to be this way because they get what they want every time.
I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail.
Again, you hear her, I've got this, I've got that, I've got more motions. I've read this thing to you before. We're going by the protocol. We've already explained it, but we'll do it again. That's what's going to make this drag out for so long, is having to re-explain everything over and over and over and over.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Do you see her going up? She does not want to hear it. But again, you hear, we're just going on a circular thing. Okay, so I have to do this? No. Here's the thing. I explain this. This is their protocol. This is how this is going to go. It doesn't matter if you ask it 10 different ways. This is always going to be the answer. We will always revert back to this answer.
I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quote, the laptop is in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of. Neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please.
Okay, 2 things. Number 1, you heard her talking about, I want the boxes. 100% get it. I would want them too. Because that's downtime that she could revert to the hard copies. So she could do double time or whatever. So that makes total sense. And I too am like, yeah, surely there's a place. I mean, it's 2 boxes, right? They could put them down on property and then bring them up to her at 4 o'clock and give her classroom access or something, right? I mean, come on. Now, you heard her at the end where she snips back. Yes, and I'm just trying to explain myself. We get it, Sarah. We're right back to, I want to explain, I want to explain.
Wow. So in over 4 years, it comes down to me representing myself in 62 days?
I'm not going to answer that question.
Yeah. Now, if you didn't understand what she said, it took me a couple of times when I first heard it. Wow. So in 4 years, it comes down to me representing myself in 62 days. And he was like, I'm not going to answer that question. I don't like that question. I don't have to answer it. I'm just like, yes, Sarah, this is what it comes down to. You should have worked with your attorneys. Ones that you're now wanting to have standby. I'm dying to know and hear it from the horse's mouth what it is that she's been wanting to spout that has made this, besides her behavior. Clearly she is coming up with some next level BS that the attorney's like, you can't do that. Or like, that's not how it works. And she's completely like, nope, we're going to do it. And I'm dying to know what it is.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you've delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order.
Oh, she's getting saucy. She's getting saucy. The real Sarah, will the real Sarah Boone please stand up? That's all that is the real Sarah coming up. She is so pissed off over representing herself, but she has zero clue that she did it to herself.
It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet.
Now, here's what's going on, just for some context, if you have not watched this and whatnot. He's coming up and talking about, like, what you see in court all the time. Okay, y'all, we need to do A, B, and C. What dates work for y'all? Sarah, when would be good for you? And she goes off into these rants, and then you heard her say, so you're making statements, so I'm going to say, he's like, I've asked you about this, and you won't answer the question. This is always a theme with defendants like this. Daryl Brooks, Sarah, Ronnie, what's his name, who did the horrible thing? The guy who was screaming and yelling at the court. court, this is always a common theme with defendants who represent themselves in this way, is they want to answer a question, they have 10,000 other things to say, and again, I get that they're learning, but it's like, just say it. Like, just throw out some samples, right? Or some, some what do you call them? Some examples to choose from, or selections, whatever. I can't think of the right word, but you know what I'm saying.
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates.
And here, again, I understand what she's saying, 100%. It sucks. She's probably hoping they'll give her access to a regular phone. You wouldn't have this issue had you handled things a little bit differently with the 8 other lawyers that you worked with. That's all this comes down to. She can say it 100 times over, we get that, and yes, you need to speak up for yourself in this scenario, but it is what it is.
So, understanding that as of right now, you do not have hard copies. You'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined, because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers.
She ain't gonna give him a date. She ain't gonna give him a date. And essentially, and he can't say this, but it's almost like, that's not my problem. We have provided you all this stuff. Unfortunately, you have forfeited your right to counsel. So this is where we're at. Figure it out. Right? Yeah, it sounds like a total pain in the ass. 100%. Totally agree with you, Sarah. Totally agree with you. I can't imagine having to do the research she's gonna have to do and doing all this stuff and using that payphone. And I get it. It's gonna be a pain in the butt.
If the defendant's not going to make a suggestion, make the state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th. And then 14 or 15 days after whichever day we get the specific list of digital evidence items to her would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this.
I'm damn speechless. Y'all, call me when this damn trial's over. I'm exhausted. Sarah, we're worn out, Sarah. We can't take it, Sarah. The courtroom is patient. The courtroom is patient, y'all. Because at this point, I don't feel comfortable. I don't feel comfortable. Just say yes and go with it and then ask for a continuance. Something, right? Again, you would think for somebody who is so hell-bent on knowing exactly how everything should go with her lawyers that she would have know half the stuff that she's complaining about, right?
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the. Figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Now this is, we need like that whole ominous like, whoa thing, like when the pearly gates open up kind of thing. The discovery is on the jump drive. Can you imagine having to do all that? And we'll hear when they talk about money here in a minute. Can you imagine having to be the person who's like scanning all that to a jump drive? Oh my God. Just if they left it up to me, they would be like, look, we've had to extend the trial out 3 years. And they pan over to me at the thing, I'd be like, I'd be sleeping at the computer. They'd be like, well, surely he's been up all night. He just scanned 3 pages and then passed out. Side note, okay, complete sofa side note. Yo, I have somehow been on the algorithm on TikTok now of people who have this condition that they pass out when they laugh. Thank God I don't have it. Yeah, they're just sitting here like, they can't say. I'm like, I would just be in a passed out state all my time. So, oh my God, I just thought of that when I thought of the passing out doing the scans in. But yes, she's getting the discovery, y'all. This is mega.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it. Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable. Yeah, if Mr. Lane, and Your Honor, in light of this, maybe it might be more appropriate for the court to go up to $10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the $5,500, or just we would increasing $5,000 to $10,000?
$5,000 to $10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have some more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that $5,000 just doing this one task.
Okay, so you heard that. They're going to increase the money up to 10 grand. Now you heard that, oh, Sarah has to sign the invoice. You know 100% she's going to sit there and drag that out. She loves that power. She'd be the type to throw a $5 bill on the ground like, pick it up, you filthy animal. You know what I'm saying? Like, you know she absolutely loved doing that. Like, oh, I'm signing off on this $5,000 invoice.
It is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. The second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, hyphen A, comma B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024 for preparation of trial in her criminal case. Just review those, Counselor, and just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the Sheriff's Office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay. All right. I appreciate that, sir.
Okay, a couple of things. So what they're doing is, remember earlier where she's talking about I have these motions, they're going over them. So the first one is she's talking about, you know, I want to basically move around the courtroom as free and blah, 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 blah. That would be an obvious thing to me that they would have to do. Now, if her behavior warranted it, so for example, if you take someone like Daryl Brooks who had these clear behavioral issues, now maybe she does the jail, I don't know. But so far she seems pretty like normal or whatever, but you never know what one could do. So obviously they also want the inmate / defendant to not look incarcerated or whatever. However they do that for the trial because it's like biased or whatever. So I get that. Now, secondly, we're right back to the hard drive. This is what the hard copies. This is what I was talking about. Remember, she wanted this in the first place. Now the judge will call her out about going back and forth on a lot of things. But you hear what he says. That's between the jail and Sarah. We are totally cool with her having hard copy. We don't care. Okay, that's up to the jail. So everything literally comes down to, I mean, within reason, her being incarcerated and how the jail handles that with security.
Ma'am, with regard to your request for discovery, the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain, to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
I mean, this is the thing. This is what I'm talking about. He's calling her out. You wanted a laptop. We got your laptop. Now you want hard copies. Now you want this. She goes back and forth with things. And my thing would be this. So I'm like this. I'm like, no, I would rather have the hard copies as well, right? I mean, I'm old school. Like if tasked with, do you want a handheld calculator or one online, like on the computer? Give me the handheld. Like I'm I'm old. I need real stuff. You know what I'm saying? So I get that. But it's her going back and forth and acting like there wasn't that before. And it's like, look, it's okay to say, you know what, I'm very appreciative of you've gotten me the discovery on the disc, and that's awesome. That's going to help me. Can I also get that? Can I also have access to the hard drive or to the hard copies? And how do we go about that? There's just a completely different way to go about this. She's probably watched a little too much TV, and she's like, I'm going to go with the hardball attorney thing, and like that's how I'm going to get my way in this.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never...
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the...
This is what I'm talking. She's going to go toe to toe with the damn judge about what she did or said. It's like, Sarah, let's all make note here. We're all collectively seeing how we arrived at the situation of not remembering we recorded the crime in action on our phones in the video, okay? This is this playing out right here in front of our eyes. And then denying it. I never asked for that. Honey, you think he's going to make this up? Why would he make it up? Why would he make it up? That's my question. What's his motivation to lie about something that petty? I mean, come on.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you when you do not have a place to store it, and the jail does not have a place to store it.
Again, let's just note his fairness. I'm not saying no. I'm taking the information that you and the jail have told me, and I don't know how to make it happen. It's totally cool for it to happen, but I don't know how to make it happen for you. I mean, it's just, you can't, I mean, the guy is fair. You got to give that to him.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by sergeants.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk.
She's got her damn Birkin bag. She's got her Birkin bag. She makes sure to do her rounds in that cell with her damn Birkin bag, y'all. Okay? 100%. But now, here's the thing. I will agree with Sarah on this. In the beginning where she says, they have a whole property room. I'm like, yes. Please, for the jail's sake, y'all have to have some place around there you can put 2 damn boxes of stuff, right? And lock it up and drop it off to her at 4. Even if you're like from 4 o'clock, I mean, I know they have schedules of stuff, but let's make this up. At 4 o'clock, they take access away from the computer. They could be like, okay, chow time is at, 5, whatever. So at the next shift, whatever the next shift begins, let's say 6 or whatever it is. Sarah, from 6 to 9, you have access to hard copies. 3 hours a night. That gives you 10 hours a day or whatever with access to your case. Thank you. Done. Okay? So I agree with her on that. Like, y'all can't find some place to store this and bring it out. I mean, come on, right? Let's, come on, bros. Like, let's make sure all things are covered. But again, like the judge and the state are saying, like, look, that's not up to us. If it's up to us, here, take it with you right now, girl. Go on. Go swim around in the pages. Do whatever you want to do.
I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion.
I mean, she's confused by their confusion. One of the things too is it's like, Sarah, when you're a person who walks and talks in circles, you confuse others and you keep revisiting a topic over and over and over and over and over, and you change it bit by bit to try and manipulate. This is why it confuses people, because they're like, where are we at now? Just the same way as he's like, but you've said A, B, and C. The jail has said D, E, and F. That's why we arrived here and we did a thing on it. Why are we switching? Why are we back here? Because she'll eventually get what she wants by doing it.
The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it.
So again, this is what I'm talking about, where she delves out the information. And like he said, I'm just regurgitating the information that you told me. Based on what you told me, this is where we're at. I don't know what else to say. I want it either.
You can have those documents. I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form. It was in digital form.
So there you go. Again, we're right back at ground zero with this stuff. And again, like I said 100 times over, I too would want the hard copies. I get that. I'm not faulting her for wanting that, but it's just like, we just keep going back over the same stuff over. You can tell the judge is getting a little irritated, right? Where it's just like, and she puts words into people's mouth, but she doesn't want that done to herself. That's the other frustrating part with her.
I don't want to ask her, but perhaps the court can ask her.
Sure. Ma'am, the state has recommended a position in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, he can release them to me?
Granted.
So she doesn't get, they have to, I'm even trying to wrap my, it's so frustrating even to listen to. The jail has a say on the hard copies. They're not denying her the hard copies. Okay, we keep going over and over, and she will never answer and give them a solid answer. This is probably another reason we're seeing why her attorneys got sick of her. She won't commit to anything. She operates in gray zones. People like this operate in gray zones. They operate in confusion, so that when you, like you heard her say, I'm confused by everybody's confusion, they create the confusion. I think she knows what she's doing, but also it's just the way they are, so they don't understand it. And when I say that they are, it's just people who live their life like this, right? It's just, it's utterly, it drives you up the wall. So yeah, the judge is like, with that last little thing, he was like, he's ready to go. We're done, Sarah. We're done.
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom, and during the evidentiary, the physical evidence, that I might be able to utilize that?
So my understanding is there was an imaging done of your phone with software called Cellbrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person to hire. I know that defense attorneys in this area hire somebody named Richard Connor.
I said in the live chat, I was like, she wants to get her damn hand on that phone because that phone, she wants to smash that thing to smithereens. That phone is the source of all this for her, right? It's that damn phone. And she wants one last round with it. Okay, she wants one last round with it. Now, again, you hear the state, they're throwing her bones. Like, okay, we can't say this, but this is what people usually do. They're not gonna, you can't. Can you imagine? It's like, why do you want your actual phone? She probably is still in disbelief. She's like, I don't think those videos. I want to make sure that's George on that video. I can hear her brain just turning right now.
As Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, an epic milestone for me to be able to finally do that.
An epic milestone. Yes, Sarah. We love it. We love it. We love this milestone for you. Every last bit of it, girl.
Your Honor?
Yes, ma'am.
I believe I am okay for right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access, where I don't know if emailing or messaging or whatever, however it is that you and I can communicate, rather than snail mail, I mean writing you a letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you already had my address correction, but I don't believe I updated.
So this, all they're doing is there's an issue with communication. He rectified that at the very beginning. She's basically like, I want to slide in your DMs. Okay, this is why they need to keep her away from the internet. She'd be talking about Facebook friending, Insta DMs, all this type of stuff, right? And it's just like, yeah, that's not appropriate on any level. I mean, I'm joking, obviously. She didn't ask to slide into his DMs or whatever. Not that I don't think she wanna, but obviously it is what it is. Like, yeah, you're gonna communicate with me through court. We fixed the address issue. Let's keep going. Now, those are all the clips that I picked here, so let's just talk about a few things here. Okay. So they're going to have several court dates coming up. I do not think that they will televise for us the evidentiary hearing, first of all. And I get that, right? My biggest takeaway from this is the plea deal. This was brought up a couple of times. I think she wants to wheel and deal. I think she wants to wheel and deal with them and see what she can get. I think one of her tactics was to drag this out and be as difficult as possible and do as much time as she could in jail, okay? And then come to them and be like, what are you gonna offer me? What are you gonna offer me? And probably be as dramatic as possible so to give them a taste of this is what trial will be like. You wanna come in, deal? And I think that's what we're going to see. Now, will they do it? I think it will be a ridiculous deal that the state would be like, absolutely not, right? So there's that. So if you are still here, I thank you very much. This was painful. Again, the link to the live chat that we did this verbatim and watched the whole thing is down below if you want to watch that. And that's it. Let me know. What do you think? The biggest takeaway I want to hear from, I mean, obviously whatever you want to talk about, but what is your opinion on the plea deal? I'm so curious about that. So let me know in the comment section, and do drop some little sofas off for myself, Roscoe, and Spirit, so we can hang out on there while we talk about this case and all the other crazy stuff we talk about here at the sofa. And until we do that and meander our way down there, we'll see y'all soon. I want to give another shout out to Tester Up for making this video possible. Again, check them out. You can find them down in the description box in that link or on the QR code. I just wanted to say thank you again for watching the whole video, and also thank you for being part of the Sofa Squad. Special thanks to all the Patreon members, channel members from both of my channels, everybody who likes, shares, subscribes, comments in the comment sections. It helps the channel out so much. Now, don't forget, I do have that other channel, the podcast channel. That's where we go live, we hang out, we talk. We have kind of sort of a schedule, but just be sure and check it out. I'll put it up here on the screen. Also, if you're looking for merch, be sure to check out my Teespring store. I'll put that up here. And then, like I said in the beginning of the video, if you want to follow me and Roscoe on the Instagram, go on, check it out. It's right here on the screen again. But once again, thank you very much. I really appreciate you being part of the Sofa Squad, and I'll see you in the next video.